Under a will-based plan, I own my assets. They're mine. And in order for someone to be able to sign my name on a deed or access my bank accounts, they first have to take my will to a judge in a process called probate. Now the judge will appoint an executor, and now the executor can go forth and take care of business, but they're still beholden to the court. They have to report back to the court when they're done, and they certainly will have to go to court if there's any issues that arise. A trust-based plan, I don't own my assets. I put my assets in an entity called a living trust, and when I die, generally there isn't a need to do this process because, after all, I didn't own anything. The trust owns it. And the trust didn't die. It tells us who's in charge next and what they're supposed to do with it. So it's a much kinder way of passing your assets.
The main difference between a will and a trust is when it takes effect. How do we want this to transition, right? Do we want it to transition through court? Do we want it to transition without court? The other thing about the trust that's different from a will is that the trust covers all of the instances of life. So, a will just deals with death, right? It says, okay, when you die, this is how you want your assets distributed. But it doesn't really help you out with incapacity. In a married couple, you've got 2 incapacities that you have to worry about. You got 2 deaths you have to worry about. That's a big concern. And so with a trust, we cover all of those.
Whether you're interested in doing a will or a trust, Moulton Offices is really here to be your guide, to provide you the education and make sure that this is as simple as it can be for you so that you can move on knowing that you did it right.